Good morning. This is an open meeting of the United States Securities and Exchange Commission on January 20th, 2011. Today, the Commission will consider adopting two sets of rules, both of which are designed to help revitalize the important asset-backed securities market by encouraging better disclosure for investors. At one time, the securitization market provided trillions of dollars of liquidity to virtually every sector of the economy. This enabled lenders to make loans and credit available to a wide range of borrowers and companies seeking financing. However, during the financial crisis, ABS investors suffered significant losses, causing the market for securitization to rapidly decline. Last year, the ABS market represented only about $110 billion in issuance. Last October, the Commission released for public comment two proposals intended to restore investor confidence in this market. Today, we are considering whether to adopt these rules. The first set of rules would enhance disclosure around ABS reps and warranties. In the transaction agreements that govern a securitization, ABS issuers or originators of the loans typically make representations and warranties about the characteristics and quality of those loans. If a loan does not comply with the representation or warranty, an ABS issuer or lender can be required to repurchase the loan from the pool or replace it with a substitute asset. Under the new rules, ABS issuers would be required to disclose the history of the repurchase requests they received and the repurchases they made relating to their outstanding ABS. This disclosure would be required to be filed in tabular format to help investors use this information to identify originators that may have underwriting deficiencies. Issuers would have approximately 1 year to establish the systems and gather the data necessary to make this disclosure before making their initial filing on EDGAR, the SEC public database. This initial filing would disclose the last 3 years of repurchase history. After the initial filing, the ABS issuer would file updated information on a quarterly basis. These disclosure requirements would apply to issuers of unregistered ABS, including municipal ABS. However, municipal ABS would be provided an additional 3-year phase-in period and would be permitted to provide their information on the MSRB's EMMA system rather than EDGAR. In the context of registered ABS, the new rules would also provide investors with ready access to the most current information regarding an issuer's repurchase history. It would do this by requiring the issuer to include in the body of the prospectus repurchase history for the last 3 years for ABS of the same asset class as the securities being registered. As with the initial EDGAR filings, this new requirement would become operable for registered offerings commencing just about 1 year from now. This first set of new ABS rules would also impose obligations on each nationally recognized statistical rating organization. Under the rules, NRSROs would have to include in any report accompanying a credit rating for an ABS offering certain information about the representations and warranties that are contained in the ABS transaction documents. Specifically, NRSROs would be required to describe the representations, warranties, and enforcement mechanisms available to investors, as well as how those provisions differ from the reps, warranties, and enforcement mechanisms in the issuance of similar securities. We received many comments on the appropriate length of a look-back period for ABS issued in the past. Not surprisingly, divergent views were expressed. Some suggested that issuers may not have access to the repurchase information for historical periods, or that it would be extremely costly to produce. Other commenters suggested that only this historical repurchase demand data will allow for an analysis of the relative responsiveness of securitizers and asset originators. Additionally, some commenters expressed the views that the purpose of the legislation, which directed the Commission to adopt these rules, was to highlight for investors the identity of those asset originators that have habitual issues with underwriting deficiencies. I believe that the staff has done a good job of balancing these competing concerns. The recommendation before us defines the look-back period at 3 years and includes relief for issuers who cannot obtain the information without unreasonable effort or expense, and phases in the requirement for prospectus disclosure over several years. All of these are rational measures aimed at providing investors with the information they need without unreasonable cost. I also know that some have suggested that we exempt municipal issuers from this rule. However, the Dodd-Frank Act did not provide us with this exemptive authority. Again, I think the staff's recommendation that we provide these issuers an additional 3-year period to prepare for the rules and the flexibility to file on Emma instead of Edgar is a reasonable way to balance concerns in this area. Additionally, before the rules become operable for municipal issuers, we will have the opportunity to consider additional inputs, including the results of our ongoing study of the municipal securities markets, the study of this market that the GAO is conducting, and the implementation experience of other issuers. At such time, we could make revisions to the rules if appropriate. The second ABS rule that we're considering today would also enhance ABS disclosure, providing investors with better information about the quality of the loans backing the ABS. Specifically, issuers of ABS that are registered with the Commission would be required to perform a review, either themselves or with the help of third parties, of the bundled assets that underlie the ABS. The type of review could vary depending on circumstances such as the nature of the assets being securitized and the degree of continuing involvement by the sponsor. For example, the type of review required for ABS backed by credit card receivables may differ significantly from the review for ABS backed by residential mortgages. Minimally, the review would need to be both designed and performed to provide reasonable assurance that the prospectus disclosure about the assets is accurate in all material respects. This new rule would also require an ABS issuer to disclose the nature, findings, and conclusions of this review of assets, as well as information about how the loans in the pool differ from the disclosure in the prospectus about the underwriting criteria, information about loans that did not meet the disclosed underwriting criteria, and information about the entity that made the determination that such loans should be included in the pool despite not having met the disclosed underwriting standards. The rule would provide a phase-in period to allow market participants to adjust their practices to comply with the new requirements. Any registered offering of ABS commencing with an initial offer after the end of this calendar year would need to comply with the new rules. When we proposed this rule, we did not include a minimum review standard, but we asked for public comment about whether we should include a standard in the final rule, and if so, what that standard might be. After reviewing the comments and considering this further, I believe that a minimum standard better serves investors' interests. Investors need to know that issuers are taking steps to check that assets in the pool are what the prospectus represents them to be. I believe the principles-based standard that the staff has prepared for our consideration strikes the right balance between providing issuers flexibility to design a standard that suits a particular transaction, while making sure that issuers do not shirk their responsibilities to perform a meaningful review of assets. In a moment, I will ask Meredith Cross, Director of the Division of Corporation Finance, to provide more details about the recommendation before us today. But before I do that, I'd like to thank the staff who've put in countless hours working on this project. From CorpFin, thanks of course to Meredith and to Paula Dubberly, Kathy Shue, Rolane Bancroft, Eduardo Ailman, Paul Dudek, Amy Starr, Cecile Peters, and Heather McIntosh. From the Division of Trading and Markets, thanks to Joe Levinson, Ray Lombardo, Randall Roy, Mary Simpkins, and Martha Haynes. Our thanks to our colleagues in the General Counsel's Office, specifically David Becker, Meredith Mitchell, Richard Levine, David Fredrickson, and Bryant Morris. From the Division of Risk Strategy and Financial Innovation, thanks to Stas Nikolova and Emre Carr, and I want to welcome Jonathan Sakobin, the Acting Director of the Division, to the table today as well. And finally, I want to thank my colleagues on the Commission and all of our councils for their hard work and thoughtful comments. And with that, I'll turn it over to Meredith.